Hi everybody, it's Andy and welcome again to my office in Modesto, California. I'm an attorney licensed to practice law in California as well as New York. In this video we're going to talk about California divorces and this supposed rumor that you can get your soon-to-be ex-wife, soon-to-be ex-husband to, during the course of your divorce, basically give you a bunch of money so that you can go hire an attorney. Is this true, or is this just yet another rumor about how California law supposedly works? So the answer to that question is it's not a rumor. It actually is true. So if this is your situation, if it's if your soon-to-be ex-husband or wife has basically said, I'm going to file for divorce, I'm going to bankrupt you, I know you don't have the money to fight this, etc. I'm just going to wait until you run out of funds. If they said something like that, the law that you want to get really familiar with is California Family Code section 2030. I'm going to go ahead and write that up over here as well as paste and link it down below for you. But because it's section 2030 of the Family Code, the motion that you submit to the court to get prospective attorney's fees is rather unimaginatively called a 2030 motion. So I'm going to tell you guys how to actually do a 2030 motion, kind of what forms to use at the end of this video, and I will go over judicial council forms, the numbers, all that stuff. But I'm going to save it to the end because I'm going to talk about section 2030, the statute, first. So if you read section 2030, the basic idea is that it allows a family court in California to order the more advantaged spouse, in terms of like resources, like financial resources, access to legal counsel and stuff, to order the more advantaged spouse to pay prospective attorney's fees and costs to the less advantaged spouse. And I'll give you some examples, I guess, of fact patterns in which I've used 2030 successfully. Other lawyers I know have used 2030 successfully. The most common fact pattern, I guess the most typical one, is one in which one spouse works, let's say the husband, I'll just pick on husbands for a second. The husband works outside the home, earns a whole bunch of money, he generates all of the household's income. The wife over here, maybe she works like a small part-time job or something, pays very little, but the thing is, she spends all of her time, all of her energy otherwise raising the children. So the wife's job over here, if she were to have to pay for a lawyer, there's no way this job would allow her to spend $300 an hour, $250 an hour, $400 an hour, etc. So if, for example, a husband decides to run off with his mistress one day and file for divorce, he might be thinking that, oh, well, I know she can't afford to fight this. I've cut off her credit cards. I've, taken her off the bank account and stuff. She'll run out of money and she'll just have to give up. In that type of situation, the risk is that husband will use his superior resources to basically push wife around, coerce, the wife, make the wife give up when she otherwise would not. And 2030 is meant to basically remedy that situation. So to basically go from something like this to something like this or like this, basically so that husband and wife are on equal footing. So in general, California tends to not like situations like this during a divorce because one spouse is definitely at risk of being pushed around. California in general also does not like situations in which a particular spouse, just because they are lower income, don't earn as much, and the other spouse has all of the earning ability. They don't want a poorer, lower income, less advantaged spouse to feel like he or she has to stay in the relationship, has to stay in the marriage, just because they can't afford to get a lawyer to get out. So if the marriage is unhealthy, if it's abusive, if it's just emotionally draining and stuff, basically if it's not a good marriage to stay in, California views it so that this spouse should not be forced to endure that just because they don't have the resources to get out. That's kind of also where 2030 comes from. So 2030 is not gender specific. So in my hypo, I basically have picked on husbands, like husband's up here, wife is down here. If it was reversed like this, 2030 works as well. If wife was the one who worked and husband was the one who was being, who was at risk, I guess, of being pushed around, he could use 2030 as well. 2030 is also not direction specific. So in my first example where husband's here, wife is here, if husband is the one who files for divorce, can wife use 2030 to get up to husband's level? Sure. However, let's say, same situation, wife is the one who files for divorce. Can she file for divorce and use 2030 to get up to husband's level? And the answer is, this might surprise some of you, the answer is yes. 2030 is not, restricted, like there's no requirement that, the less advantaged spouse rather, can only use 2030 if they are the ones who did not file for divorce. There is no requirement like that. 2030 doesn't really care, I guess. It doesn't care who filed for divorce, who didn't, etc. It applies regardless. So that said, I'll tell you guys a couple ways, or I guess one way in which to do a 2030 motion. The way that I would normally do it, I have a standard motion that I have written and kind of refined over the years. Most lawyers I know have kind of template motions that they've kind of refined over the course of their careers. If you are doing a 2030 motion, there's a good chance, I think, you are doing it on your own, like you have no attorney helping you. So if you're going to do that, the easiest way to do it, I think, is probably going to be to use judicial counsel forms. So I have a separate video about how to download judicial counsel forms. I'm going to link that over here. So go ahead and look at that if you haven't seen it already. But the basic idea is you're going to need at least 3 judicial counsel forms, possibly a 4th one too, depending on your county's local rules. So the 3 that you definitely need are going to be the form FL 300. That's the general request form for any kind of court order. So the form 300, the form 158, and the form 319. So the 158 and the 319 combined are going to contain a lot of the information that the court needs to determine whether or not prospective attorney's fees are appropriate, if so, how much, etc. So 2030 is going to require 158, the form 158 or form 319. Make sure you don't leave those off. And the last form number 4, which most likely will be required, is the form FL 150. And I have a separate series of videos about how to fill that out. Because it's a playlist, I can't fit all the videos over here, so I'm going to actually link it as a card right over here. So go ahead and take a look at that. Hopefully that playlist is self-explanatory. But a current income and expense declaration is going to be one that is dated within the last 90 days. In most counties that I've been to, at least, their local rules, their family local rules rather, require a current income and expense declaration if a request for prospective attorney's fees is made. So that's actually fairly critical. If you don't know what a local rule is, I have, I think, 2 videos on that, which I'll link right over here. But it's a fairly critical requirement, I think, because if the local rule says that you have to have a current income and expense declaration, on file, and you don't, you could write or submit the best 2030 motion ever, present the most compelling case ever, and the judge will rule against you. It's nothing personal, it's nothing nothing about the merits of your case. You just have not complied with the local rule. So if you are going to do a 2030 motion, check your local rules to see whether or not a current income and expense declaration is required. If it is, I'm willing to bet most likely it is, make sure you do one. That's the big takeaway. So this video had a lot of stuff in it, and I usually don't link to this many videos over here. But the basic idea, though, is that a 2030 motion definitely is something that can be done. It's not gender specific, it's not direction specific, but the precise forms that you need will possibly vary a little bit based on which county which county you're in. But it's something that hopefully you can go and sort out. Yeah. So anyway, hopefully that wasn't too confusing. Go ahead and like, share, comment, subscribe, all that nice stuff, and I will talk to you guys next time. Thanks.